Good evening, everyone. Thank you for coming to the Jewish Museum. My name is Jens Hoffmann, and I'm the Director for Special Exhibitions and Public Programs. And before we begin, I would like to thank Lorraine and Martin Beitler, who originally gifted this set of works by Andy Warhol, the 10 portraits of Jews of the 20th century, to the museum in 2006, and also funded this series of talks, Wish You Were Here. So thank you very much for your support. I don't know how many of you have actually been here and seen some of those talks. Anyone? So you probably have noticed that I always do the same introduction. I was trying to think about doing a different one, and at the same time was like, well, this is actually exactly what I want to say, so I'm going to do this one more time, because we're also winding down. This is number 8 in a series of 10 talks, and we might continue, but with other characters that you haven't seen yet. So the whole project really began when I started working here and started looking at the collection of the museum and noticed this particular work. And this work by Warhol includes some of my all-time favorite Jewish characters, Sigmund Freud, Gertrude Stein, Franz Kafka, and of course the Marx brothers that are particularly dear to me. And some of you have been and seen some of those. And as you know, we're also going through a lot of transformation, and there's a very exciting new chapter of the museum starting in the fall with a complete collection redesign and rehung that we are very particularly excited about. And so we have spent a lot of time looking at our own history and looking at our collection and investigating what all these objects are and what they mean. And this program is also a reflection of this interrogation into our own history and our current realities as a museum. The piece, these 10 portraits were last shown here at the museum in 2008. So it's been a while, and hopefully we'll be able to present them in our new collection display very soon. One of the interesting things about this piece, and then I'm just going to move forward because this is our guest tonight, is that Andy Warhol, who made this piece, never met any of these characters. I was kind of keen on meeting them because I was very interested in what they have to say and how we can transport the thoughts and ideas that these people have put forward into the present. And when I work as a curator, I work a lot with historical material, and I always try to think about, like, how do I contextualize this for our present moment, for the contemporary times that we live in. And in some way, this program isn't really different. I'm trying to look at personalities that have put forward ideas that really have shaped the 20th century. So the whole series is conceived as such. And I was thinking, so how do I get in touch with these people? They're obviously dead. Originally, the whole idea was met with a lot of skepticism, and I was myself not sure how to do this. Maybe it would be too gimmicky, maybe it would be nonsense, or maybe it would be just absolutely absurd to begin with. And I started thinking, like Ouija boards, maybe crystal balls. I made actually a trip to Germany, to the Black Forest, to consult the famous witches there, and they couldn't help me either. And then I came up with the most pragmatic idea that really led me to the method of how we are doing this, which was simply to ask people who are experts on the lives and works of these personalities or who have a close affiliation to their practice to come and speak in the first person in a conversational setting here with me about the work. Tonight we will meet Louis Brandeis, and Louis Brandeis will speak through Jeffrey Rosen. And Jeffrey Rosen is the president and CEO of the National Constitution Center, which is in Philadelphia. He's also a professor of law at the George Washington University Law School and a contributing editor to The Atlantic, which is one of my favorite magazines, if I may add. Rosen is a graduate at Harvard College, the Oxford University, and Yale Law School, which is all very impressive. I barely made it through high school. His new book, Louis Brandeis, American Prophet, is here. It was published last year and it coincided with the 100th anniversary of Brandeis' confirmation to the Supreme Court. And I know that Jeffrey is going to stay after our conversation a little longer over there and do some book signing. It's a wonderful book. I read it last night and can only highly recommend it. So I would like to take this opportunity to thank Jeffrey Rosen for agreeing to be part of this perhaps unusual experiment. And I would also like to thank Jenna Weiss, who is our curator, manager, coordinator of public programs. She's been, for the last couple of years, working with me very, very closely on conceiving these conversations. And a big thank you and an applause to her. And lastly, one of the things I wanted to mention, you will see that you have note cards that have been handing out, and I would encourage you to perhaps write questions on those note cards for Mr. Brandeis. And we collect those note cards at the end of our conversation, and then I will ask Justice Brandeis to answer them. So please join me in welcoming Louis Brandeis.
Good to be here.
Good afternoon.
Please.
Thank you. So I'm very glad that you are here. Thank you very much. I think it's an important moment to actually talk with you, given the political situation. And perhaps at the end of our talk, we can sort of go a little bit into that. But obviously, our main objective is to learn a little bit about your ideas, your biography, your background, what your main contributions are. And I wanted to begin at the beginning and start asking you about your upbringing. You were born in Kentucky, in Louisville, in 1956, and you...
1856.
1856, yes, sorry. 1856. As the son of immigrants from Bohemia. And one thing that I thought was interesting about it, how did a Jewish family from Bohemia, go to Kentucky? I don't think that was particularly common at that point.
My parents were pilgrims of 1848 who set out in search of America and liberty. There were revolutions across Europe that were failing, that were being crushed. And my father escaped from Prague. He was ill, so he avoided being prescribed by the emperor and was able to flee. And he set out with 2 grand pianos and crates of books in search of a farm where he could bring his beloved wife, Frederica Weil, who he recently met, and find the freedom that had been denied him by the tyrants of Europe. And that hunger for liberty suffused his being. And I was fortunate enough to have imbibed it and to be a prophetic crusader for liberty throughout my life. And I learned from my father the virtue of tilling the land, of cultivating on small farms in small-scale communities, self-possession, self-government, and education. My father taught me that only in small-scale communities can people master the facts that are necessary for personal and professional self-government. And in large states and large businesses, we're cursed by bigness, and we can't understand the facts, and we can't achieve self-mastery. So that led in me a lifelong attraction to agrarian values, to the land, and to the south of my birth.
Here in Louisville, they actually put up a nice memory plaque for you. And I was straddled by this fact, but I think you explained this very well. One of the questions I had actually was your family religious at all? Or did your father, who you just spoke about, have any particular political beliefs that led him to believe in what you were just talking about in terms of looking at the people in the smaller communities?
My mother and father were descendants of a sect of Judaism called Frankism. Jacob Frank was an 18th century Messiah who was a precursor of what you call today Reform Judaism. But my mother raised me without organized religion. She said that virtue and truth and love are the only things that endure. And therefore I raised my children without ritual so that they could repose in morality and truth. God has blessed my efforts. We were not observant. My brother and I were criticized for riding horses on Yom Kippur, but it wasn't until later in life that I came to understand that the Jewish people must be preserved, that they needed a homeland, and I became the leader of the American Zionist movement, and I convinced President Wilson and the British government to recognize a Jewish homeland in Palestine.
Yeah, we're going to get back to that a little bit later in our conversation. I have some questions for you that relate exactly to what you were saying, because there is a rumor that you were supposedly nominated to be the first president of Israel, but perhaps we get to that a little later. I'm just putting this out there a little bit as a cliffhanger, because I think this is a very interesting story. So you just spoke about your parents, but your parents were not the only influence on you. I read that you had an uncle called Louis, that had a very big influence on you as well. And I wanted to ask you, what was Uncle Louis' role in your upbringing, and how did he form you? Because in what I was reading, he came up quite often.
Louis Dembitz was a noble Jew. That's what Jacob de Haas, Theodore Herzl's American secretary, said to me when I first met him. And that statement kindled my desire to learn more about Orthodoxy and Zionism. Louis Dembitz was the only Orthodox member of our family. While we were riding on Yom Kippur, he worshiped at a synagogue not far from that house that you saw a moment ago, a synagogue and a congregation in Louisville that still exists. Louis Dembitz was one of 3 Jews at the Republican Convention of 1860 who voted for Abraham Lincoln. He observed the Shabbat. I admired his learning and his devotion to the book so deeply that I changed my middle name from David to Dembitz to honor him. He was a taskmaster. It wasn't until I was offered a professorship at Harvard Law School that Uncle Louis said, "This is the first time that I'm glad that you changed your middle name from David to Dembitz." But I was so proud to receive his pride, and he inspired me in my journey towards Zionism.
Here are some pictures of you at younger ages, also with your brother Alfred over there.
Yes, I loved Alfred so much, and we got into a lot of trouble on the 4th of July when I was about 10, because we blew up some big fireworks which upset the neighbors. But we hiked together throughout our lives. When we were adults, we went canoeing, and we wrote very affectionate letters to each other, and he was my dear, dear brother. I loved him so much.
You were educated not only here in the US at the Louisville High School, but after I think your father had a business failure with his agricultural business, you moved back to Europe and lived in Austria and Germany. I think you went to school in Dresden. Can you talk a little bit about that, and also how the education that you received in Germany sort of influenced your vision later on? And I'm saying this is all still in your teenage years.
Yes, the crash of the 1870s, caused by reckless bankers who took risks with other people's money, briefly ruined my father, but he was resilient and optimistic, and he set out to educate us in Germany. In Dresden, I learned the importance of facts I had to talk my way in to the school because I didn't speak German and wasn't able to pass the entrance exams. But having been admitted, I earned among the highest marks in the history of the gymnasium, and I learned that by reflecting on facts, I could change my mind. And that mastery of inductive reasoning led me to resolve never to be mastered by anyone, in a matter of fact. But in Dresden, I detected tyranny and oppression. Once I left my key when I went out late at night, and I whistled for my roommate to throw down the key, and a policeman arrested me. And at that moment I thought, in Kentucky, you could whistle. And I yearned to go back to America and to study law at Harvard so that I could learn about and defend the liberties in America that were denied me and my parents and others in Europe.
What was the political circumstances when you were in Germany?
I was studying so hard that I did not follow the intricacies of 1870s German politics.
Who would have done that, obviously? So, as you just said, following your return to the United States, you went to Harvard, and at a fairly young age, actually at 19, you started attending the school and graduated in 1877 at the age of 21, which is extremely unusual, and I think that the law school had to make a special case for you to be able to graduate at such a young age.
I loved Harvard Law School so much. It was an intensely intellectual environment. I heard the last lectures of Henry Adams. I read Emerson. I dined at the home of my beloved teacher, James Russell Thayer, the strenuous advocate of judicial deference. My eyes failed me at the time, and friends had to read to me so that I could master my studies. In the morning, they would read to me in law. In the evening, in Goethe and Schiller and the German classics. And through hard work and devotion to my studies, I achieved the highest marks in the history of the school. They have not been surpassed to this day, and the school made a special exemption, allowing me to graduate at the age of 21.
You're making me feel incredibly unaccomplished.
Through education and self-discipline, you are capable of developing your own faculties, as I developed mine. You must apply yourself to your studies so that you can achieve your full potential as a scholar and a human being.
Well, I think if it wouldn't have worked out as working in law, you could have been an excellent motivational speaker as well.
It is important to motivate the people to educate themselves. There is nothing more important than education. All of you have come here to educate yourself about my life, but you have an obligation to educate yourself not just about these important Jewish figures, but about poetry and about law, and above all about the Constitution, so that you can fully participate as citizens in American democracy. Education and the duty to develop our faculties comes from the Enlightenment. Jefferson, my great hero, talked about the duty of all of us to develop our faculties. We have certain faculties ranging from passion at the bottom to reason at the top. And only by assiduous self-discipline, by study, by eating and drinking less, and reading and thinking more, can we develop our faculties of reason in a way that will allow us fully to develop our potential.
Yeah, you're saying drinking less and they're throwing their glasses away.
It was empty, thank God.
So you begin practicing law. Here we have you in your Boston office. Do you remember the date? I couldn't find the date for the image.
That would have been in the 1890s when I started off in Boston and became the people's lawyer.
And one of your big objectives or big ideas at that point was the idea of the right of privacy, which, of course, in the age of wiretapping, is a particularly important subject, and which is, about the concept of owning or controlling the information about yourself and having certain rights in regards to this. Could you talk a little bit more about that?
Yes, the 1890s were a time of new technologies. In particular, the instant camera and the tabloid press that guaranteed that what used to be whispered in the closets was now shouted from the rooftops. My law partner, Samuel Warren, was affronted by articles in the Boston tabloids describing the friendship of his young wife with Grover Cleveland's daughter. And these invasions of social privacy led Warren and I to scour through American law in search of some kind of remedy for offenses against dignity. What an indignity to be gossiped about in light items that invade our social space. And yet, we could not find in American law any remedy for what the Romans called offenses against honor. American law, unlike European law, is focused on protecting liberty rather than dignity. And so we proposed a series of new causes of action that would provide remedies for the publication of truthful but embarrassing information of the kind that was described in the Boston papers. They survive to this day. They're known as intrusion on seclusion, intentional infliction of emotional distress, placing people in false light. And this became the most influential article on the right to privacy, I'm told, ever written. But soon after I wrote it, I reread it, and I concluded that it wasn't as good as I thought it was, because I came to realize that there was a fundamental clash between the right of dignity that I embraced in this article and rights of free expression. Why should it be up to judges to decide what sort of truthful information is or is not in the public interest and what the public has a right to know? I became increasingly interested in transparency. I wrote to my beloved Alice, sunlight is the best disinfectant, electric light the most efficient policeman. And I came to believe, in reflecting hard on the matter, that in clashes between free speech and dignity, free speech should always triumph, and I reconceived privacy in response to new technologies that I anticipated in the 1920s as a kind of intellectual privacy, an immunity from surveillance against intrusive technologies and unwanted surveillance, which is ubiquitous in this world. And when I realized that intellectual privacy, rather than dignity, must be protected, then I came to see that rather than clashing with each other, free speech and privacy could reinforce each other.
How do you feel about how these principles of privacy have held up in the 21st century when microwaves can turn into cameras?
I anticipated these technologies. When forced to confront the constitutionality of wiretapping in 1928, my colleagues on the court held that because there was no physical trespass involved in the wiretapping of a suspected bootlegger, there was no violation of the Fourth Amendment, which protects the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures. But I had in my desk drawer a clipping about a new technology. It was called television. I misunderstood the television of the time. I saw it as a two-way technology where people could look through both ends of the camera and see each other. I anticipated what I think you call today Skype. So my law clerk convinced me to take out this reference to television. But I alluded to it, and in my dissenting opinion in the Olmsted case, which all of you must read because it anticipates and shows us the dangers of unregulated surveillance, I predicted ways may someday be developed by which it's possible, without physically intruding into desk drawers, to extract secret papers and introduce them in court. Advances in the psychic and related sciences will make it possible to reveal unexpressed thoughts, sensations, and emotions. At the time of the framing of the Constitution, a far smaller invasion the general warrants that sparked the American Revolution were held to be unconstitutional, I insisted that the Constitution be translated so that it protect the same amount of privacy from ubiquitous surveillance that the framers took for granted in the 18th century, and I'm gratified that the Supreme Court is beginning to answer my challenge.
You already mentioned your wife, Alice. Here we have a portrait of her, and I know that you married Alice right after you wrote the Right to Privacy. Maybe you just want to tell us a little bit about, if that isn't invading your privacy, how you met Alice, and I mean, there's the saying that behind every great man, there's an even greater woman. And I know that Alice was an activist and very active in organized labor, industrial reform. She was also part of the American Zionist movement. So tell us a little bit about her and your relationship, and if she had any influence or advice that she gave you in the matters of your work as a lawyer.
It's so wonderful to gaze on her again. We were second cousins, and of course we played together as children do. But we became intimate during a sad time. It was the summer of 1890, and my beloved sister, Fanny, had just committed suicide because she was so upset about the death of her beloved child. And I met Alice. We spent time together. She consoled me, and I realized that I'd fallen in love. And I wrote to her, I have seen the longed-for new dimension. It must be depth. I look into your eyes, and I behold the infinite. And we were married soon after, and I wrote to her nearly every week. And she advised me, and she guided me, and she was a remarkably intelligent woman who was a crusader for progressive causes for our friend Senator La Follette. And she ensured that during our time together in Washington would be full of as much learning as possible. And every Sunday she would gather the most interesting and intellectual thought leaders and politicians and artists in the country so that they could speak to me and I could learn from them. And she would ensure that our learning time together was of maximal use. And I wrote to her with love until the end.
Let's move back to your work as a lawyer. By the beginning of the 20th century, you had become one of the most consultant lawyers in the country, and were able to offer a lot of pro bono work. And I wondered, it gave you the nickname the People's Attorney. And I was wondering if there was anybody else in the United States that was doing this kind of pro bono work, engaging particularly with the matters of the common people.
There were other important members of our crusade, and there were other Boston lawyers who deserved the sobriquet, the people's lawyer, as much as I. But I became convinced that it was my mission to represent both labor and capital, and to be a kind of counsel to the situation, so that through common reason, all parties could converge around a moderate result. I represented both unions and business, like Edward Filene, the head of Filene's Basement. I championed savings bank reform as a great way of ensuring that citizens were not exploited by rapacious insurance companies owned by my nemesis, J.P. Morgan, who took those reckless risks with other people's money investing in complicated financial instruments whose value Morgan couldn't possibly understood. When the bets were good, the stock market rose. When they went bad, the people suffered, and he set out with the cash. And that was why, in that book from 1913, Other People's Money and the Risks the Bankers Take with It, I explained that bigness in corporations, creating tentacles of Hydra-like interlocking directorates, all controlled by Morgan, had to be broken up, because only in small-scale banks, like the small-scale savings banks I created in Massachusetts, supervised at the state level, not by Washington or by huge hydras like Morgan, could people invest prudently, not in the stock market, which I considered a form of legalized gambling. And I predicted the crash of 1929. I said to my brother Alfred 2 years before, it baffles me why people don't go absolutely broke. And as a result of my prudent decision to invest only in government bonds rather than in reckless investments, I made $1 million by the time I was 30 and died with a comfortable amount, allowing $3 million, more than 30 million in today's dollars. That allowed me to live simply. I spent only 10% of my income on my modest living expenses, so I could invest in my wife Alice, in the education of my beloved daughters, and save the rest, so I could devote myself to the public interest. Some men invest in yachts and jewels and diamonds. I invested my surplus time in the public service so that I could try to serve the public weal.
Well, listening to some of the sentences you just said, I'm reminded of another Jew who was actually more from the 19th century, Karl Marx, and I wondered if any of his thoughts about certain labor practices, etc., surplus, entered your mind or were part of your sort of thinking, and if that ideology had any relationship to what you were doing in terms of sticking up for the common people.
Marx made a great error. He embraced bigness in government. He put too much faith in the state. His heart was in the right place. He understood the plight of the workers and the need to have decent and dignified living conditions that would allow workers to fulfill their faculties. But he wrongly assumed that by empowering government to protect the interests of the workers, that self-actualization was possible. Conversely, the conservative critics of the New Deal, which also embraced a form of big government, put too much faith in big business and supported the likes of Morgan. I criticized bigness in business and in government. I understood, I'm convinced, I'm trying to persuade you now that government authority, like corporate authority, leads to tyranny when it is concentrated in large organizations. The framers of the Constitution sought inefficiency in order to protect liberty, and only in small states and small farms can people fulfill their faculty and achieve liberty.
By today's standards, hearing what you say, you would be, without a doubt, called a radical. Where do you see the legacy of your thoughts that you expressed right now still existing within the 21st century?
I was called a radical in my own time. I insisted that by insisting on the centrality of facts, I was merely pointing out what every fool knows. In this time, I should be embraced by civil libertarian liberals and libertarian conservatives. And yet, the same civil libertarian liberals who embrace my distrust of big corporations lack a similar distrust of big government, and the libertarian conservatives who dislike big government lack a similar distrust of big corporations. My hero was Jefferson, who mistrusted big government and big business. We need more Jeffersonians today.
We have heard a lot about your legal achievements. Here's a little photograph again of you working there in your law office, and I wanted to sort of see if you feel that any of your legal achievements, if there's one particular one that you feel most proud about, that stands out in the history of many of your achievements.
I'm proud of the savings bank insurance that we created, which persists until this day. In Massachusetts, savings bank insurance celebrated its 100th anniversary. But I'm not proud. I'm speaking to you the truth. This is not my idea. I'm channeling the truth, the unbroken truth, as it was revealed from the prophets of ancient Greece, who were my heroes when I read Alfred Zimmerman's great book, The Greek Polis. It was in 5th century Athens that people first deliberated face to face and learned the importance of developing their faculties by using their leisure time for self-education. I was so excited to learn that the Greek word for leisure is ascholai, or unemployment. What a happy land that uses unemployment for developing faculties. And I came to believe that in 5th century Athens and in the Jeffersonian shires that were the successor to those Greek ideals, could people fulfill their faculties. So my achievements are to speak truth, to understand that truth comes down in an unbroken stream from the Greeks through Jefferson, through defenders of liberty in every age, and to the degree that I was able to inscribe that passion for liberty in my books, like Other People's Money, and in my judicial opinions, I will have been a prophet of liberty and served my purpose.
There's a particular case that I wanted to ask you about, which led to the Brandeis brief, which was taking place in Oregon, where you were asked to defend the maximum hour law for working women. Can you tell us about this case and how it unfolded?
There was a terrible injustice in the land, appalling working conditions that led men and women to work here in New York in sweatshops, in fetid bakeries with small rooms and no ventilation. And women, young women, were being exploited. They were breathing the baking dust. They were harmed industrially, and their very livelihood was put at risk. The New York legislature, like legislatures around the country, passed laws imposing maximum hours and minimum wages to protect workers from exploitation. And yet the conservative Supreme Court of the day struck down these maximum hour laws for men on the grounds that the liberty of contract, which does not appear in the text of the Constitution, forbade them. So when I had the opportunity in 1908 to defend maximum hour laws for women, I needed to present facts to the justices to show them the effects of these terrible working conditions on individual women. I scoured Europe, and with the help of my brilliant associate, Josephine Goldmark, my wonderful relative, we found industrial reports from countries across Europe showing these terrible working conditions for women. We showed how women were affected by these conditions, and we showed how maximum hour laws would improve their conditions. These facts were so persuasive to the justices that they cited in their opinion the able brief that we had filed together. I was so impressed by Josephine Goldmark's brilliant efforts that I changed my mind about women's suffrage, and having previously and short-sightedly opposed it, I came to realize that brilliant women, like brilliant men, must work side by side to develop their faculties to defend liberty, and I came to be a champion of the need for women's suffrage. And my brief, my Brandeis brief, I can see now inspired Thurgood Marshall when he wrote his brief in Brown versus Board of Education, which struck down school desegregation, and inspired Justice Ruth Bader Ginsburg when she wrote briefs defending women's equality in the 1970s. I am satisfied that my defense of women's equality in 1908 inspired Justice Ginsburg decades later.
One of the things while you're talking here and also by looking at your book about you that Jeffrey Rosen wrote, I couldn't help but think, well, with all these things, Brandeis must have also made a lot of enemies. And in 1916, January 1916, Woodrow Wilson nominated you for Associate Justice of the Supreme Court, and it took 125 days till you were actually affirmed. Had any of those cases that you had previously, your fights with the big banks, anything to do with it taking so long for you to be finally affirmed as a Supreme Court judge?
Yes, of course I made enemies, as one must. In fighting for the right, it is important to be merciless in defense of the truth. And the case against me took two forms. Part of it was my religion. These objections were veiled. I was called an emotionalist, a muckraker. My manners were questioned, and I was accused of an Old Testament cruelty. When I was nominated, the New York Sun's headline was, "Brandeis appointed because he is a Jew." And the claim was that Wilson had appointed me in order to win the Jewish vote in New York. As it happens, he lost New York. So part of the objection was anti-Semitic. But the stronger objection was because of my so-called radical views. My enemies in the corporate community amassed against me. The New Republic magazine published or proposed to publish a chart showing the interlocking web between the House of Morgan and Abbott Lawrence Lowell, the anti-Semitic president of Harvard, and State Street bankers and Wall Street financiers and all of the men at the Somerset Club in Boston who signed a petition opposing my nomination. At the last moment, the New Republic magazine decided not to publish this chart because the publisher of the magazine, Willard Straight, had worked for J.P. Morgan, confirming my predictions about the powers of our financial oligarchy. And yet, with a Democratic Senate and a Democratic president, after waiting 125 days for confirmation, a record that was not surpassed, I see now until January 19th, 2016, nearly 100 years later, when Merrick Garland waited longer than 125 days, I think it was 300 days before his nomination was withdrawn, I was finally confirmed by the Senate to be a justice on the US Supreme Court.
You had a particular relationship to FDR, who in fact called you an American prophet, and he gave you a nickname.
Yes, he called me Old Isaiah. In his more affectionate moods, he would call me my dear Isaiah. He saw me as a prophet. He recognized that in me. But he did not heed my prophecies. I called his advisors to my home in California Street, soon before the Supreme Court was about to strike down the most centralizing aspects of the New Deal, aspects that I detested, like the National Industrial Recovery Act, which recreated in big government the same curse of bigness that I denounced in business. And I told his advisors, Tommy Corcoran and Adolph Burl, "You must go to the president. Tell him that unless he stops this business of centralization, the court will stop it for him." Roosevelt didn't heed my prophecies, and weeks later, I joined a unanimous court on what Roosevelt called Black Monday, in striking down the most centralizing aspects of the New Deal. I'm told that Roosevelt was stunned when he heard that I had joined the majority. But he heeded my warning then. And if the first New Deal, according to the historian Arthur Schlesinger, breathed the spirit of Herbert Croly and Theodore Roosevelt and the New Nationalism, the second New Deal breathed the spirit of Louis Brandeis and Woodrow Wilson and the New Freedom. And the capstones of the second New Deal included The Glass-Steagall Act, which separated commercial from investment banking and maintained financial stability until it was dismantled in the 1990s and led to future financial crashes. I'm glad that Roosevelt eventually heeded my prophecies, but some of his successors have not.
So it sounds like there was a different relationship between the court and the president as we know it now. How do you think this has changed, and what do you think are sort of the outcomes of that change of relationship?
I talk frequently to the president. His advisor, Felix Frankfurter, was my colleague and student. I sent Frankfurter money to fund the Zionist cause as it took place. I went to Roosevelt to try to persuade him to allow in more Jews as the Shoah began. And he neglected my plea, and the British government neglected my plea. But I went to Wilson and told him to recognize the Jewish homeland in Palestine. And Wilson heeded my plea, and the British government heeded my plea. I talk frequently to presidents, and sometimes they listened, and sometimes they did not.
You served on Taft's court, and I wanted to see if you could tell us a little bit about your relationship to Chief Justice Taft, and about also perhaps learning how to make compromises.
Taft and I had a rough beginning. I was the head of the congressional investigation that led to the greatest scandal of Taft's presidency. It involved environmental policy, and Taft was trying to put Theodore Roosevelt's environmental policies on firm constitutional grounds. He was a constitutionalist, a former judge who yearned to be Chief Justice. He hated being president, and although he was not a successful judicial president, he was an extremely successful presidential Chief Justice. And during this investigation, I revealed, through rigorous investigation of the facts, that Taft had backdated a report exonerating one of his environmental aides, and this caused embarrassment to the president, although he himself had done nothing wrong. But although Taft opposed my confirmation, we became close on the court, and I came to admire him as a successor to John Marshall, who put the ideological legitimacy of the court above his own personal ideological predilections. Taft had a skill, like Marshall, of massing the court, of convincing us to converge around narrow, unanimous opinions. He disliked dissenting opinions, and I often suppressed my own dissents when I felt liberty allowed it and the institutional legitimacy of the court permitted it. So this judicious man deserves credit, and I am urging you to re-examine the legacy of President Taft and Chief Justice Taft, and you can do that next year when Jeffrey Rosen's book on Chief Justice and President Taft comes out, and I understand that it will be insightful.
You saw an early draft.
No, I understand that it will be insightful.
So following our last question, or my last question, can you speak a little bit about the famous Ashwander decision, which apparently is still cited a lot by Republicans and Democrats alike?
Chief Justice John Roberts is an acolyte of Taft in putting the institutional legitimacy of the court above his predilections. And he cites the Ashwander case on behalf of the proposition that when it's not necessary to decide a constitutional point, it's better to decide the case narrowly so that all sides can agree. That beautiful principle of judicial deference animated Roberts' dissent in the healthcare case, where he put the institutional legitimacy of the court above his own ideological predilections. He, like Taft, is one of the Marshallians and deserves credit for his patriotic devotion to judicial deference in that case.
You already mentioned that Alice, your wife, on Sundays would hold salons. And I was wondering if you could be a little more specific about who you had there as guests in your Sunday salons.
We had all of the figures in Washington at the time who could educate me so that I could gather facts, so that my decisions could be well informed. And I was particularly taken by a young senator, Harry S. Truman. He also had a horror of the curse of bigness. He was a foe, like I, of monopoly. We were in complete agreement about the curse of bigness, and he also was an autodidact who educated himself about facts, about the classics. He read the Greeks, he read the Romans. My apartment during these teas was decorated austerely with prints of classical ruins in order to inspire my guests to devote themselves to self-education, and Truman and others answered the call.
You had two daughters, Elizabeth and Susan, and I have two pictures here, and then also you with your daughters building a playhouse. Tell us about them. Did they at all, were they at all interested in law? Did they step into your footsteps? What happened to them?
These brilliant daughters were such lovers of learning. I devoted each morning at breakfast from 7 to 8 to reading to them from the Greeks, from mathematics, from poetry, from history, in order to kindle in them a love of learning. And they responded to my call. Susan became a regent of the New York Board of Regents, a leader of Hadassah, and a seeker of truth. Elizabeth went to the University of Wisconsin, got her doctorate in history, and wrote a definitive 3-volume history of labor in the United States. Neither of my daughters could possibly have made me more proud.
Congratulations.
Congratulations to them for developing their faculties and making the most of the opportunities that were given to them.
So, talk a little bit about your relationship to religions and any of the factors that eventually led you to become more involved with the Jewish community and particularly with the Zionist movement. And we talked a little bit about this early on, but I wanted to go a little bit more in depth about this.
2 incidents kindled my interest in Zionism. Before 1910, I had been a stranger to the Jewish people. I came to embrace the Jewish cause in 1910 when Theodor Herzl's American secretary, Jacob de Haas, visited me. He told me that Louis Dembitz was a noble Jew, and I began to read about Zionism and recognize its importance. And then that summer, I represented Jewish garment workers in a strike in New York. It was the first time I'd met Jewish immigrants from Eastern Europe. My parents were from Prague, and I knew German Jews of the more privileged classes. But these Eastern European immigrants impressed me with their intellectualism, their devotion to learning. They used their moments of leisure during this strike to read industrial reports and Tolstoy and cultivate their minds. And I was impressed by the empathy of their employers, who were also Jewish. And I came to believe, I came to understand, that the Jewish people must be preserved. But then I faced a difficulty. I had previously embraced Theodore Roosevelt's hatred of hyphenated Americanism, the idea that being both Jewish and American was a kind of dual loyalty. And I came to realize that by being better Jews, we could be better Americans. And rather than embracing a melting pot, only by embracing an ideal of cultural pluralism could every group and nationality develop its faculties and contribute to the orchestra of the American whole. So I came to realize that the Jewish people, like every other nationality, needed to be a majority in its own home. And I came to realize that Palestine was that home, and that Palestine had to be the home for the Jewish people. American Jews did not have to move to Palestine, but all Jews across the world had to have the option of a state that was democratic, secular, free, respected the equal civil rights of Jews and Arabs, and I was confident, and I knew that together Jews and Arabs could cultivate the land, eliminate malaria, make milk and honey flow. And I was so thrilled to visit Palestine and realize that it was indeed a miniature California, where the desert turned to vineyards. And on small-scale kibbutzim, I saw the apotheosis of the Jeffersonian shires and the Greek polis that I knew would allow men and women to develop their faculties. And I am glad that I devoted what modest energies I had to persuading America and Britain to recognize a homeland in Palestine.
So how has your vision for Israel worked out, in your opinion?
I could not have anticipated the intensity of nationalism of both the Jews and the Arabs. I was romantic in imagining that both groups would work together, respecting each other's liberties on behalf of a common cause. Nationalism was and is a force that is dissonant with my Enlightenment faith in reason, with my Jeffersonianism, with my agrarianism, and with my optimism. But I am always optimistic, and my faith in time is great, and I remain hopeful about the apotheosis of the democratic Jewish state that I envisioned in Palestine.
Here's actually a photograph of you visiting Palestine in 1919.
I was greeted by a band of Boy Scouts who showered me with flowers and sang Hatikva.
Here documents a draft copy of a speech you gave.
I gave many speeches. I insisted men, money, discipline. The Zionist movement was in disorganization. The finances were being mixed. I insisted on Taylorite industrial principles to ensure that the money was devoted to agricultural reform and to the cultivation of the land rather than to internecine battles. I helped to raise millions of dollars, and because of my efforts and those of the toilers in the vineyards on behalf of Jewish state, we were able to achieve our goals.
You were also a man, or known as a man of many quotes, when I prepared myself for our conversation. And one of those, these are some of the ones that stood out for me here, particularly the ones on the top. Most of the things worth doing in the world had been declared impossible before they were done. And I can see now from our conversation that must have been really the guiding principle of all of what you were doing.
The guiding principle of all that I was doing was to protect liberty. My father came to America for liberty. Jefferson and the framers risked their lives for liberty. That's why I said that the greatest danger to liberty lurk in the insidious encroachment by men of zeal, well-meaning, but without understanding.
I found this cover of Time magazine, published in 1937, and in the magazine you're described as a crusader for anti-corporate tradition, and I wonder how you think those sort of sentiments are being upheld or maybe even resurrected at this particular time within the courts of the United States.
I was a crusader on behalf of a constitutional tradition that began with Jefferson, who proposed a constitutional amendment to the Constitution that would have forbade Congress from establishing monopolies or corporations with exclusive privileges. It was continued by Andrew Jackson, who denounced the hated Bank of the United States and the centralizing threat it posed to liberty. It was carried on by Wilson and I, and then by Roosevelt after he was chastened by the court, and then by Harry Truman. But then this tradition of a hatred of business, a defense of the small man, the small worker, and the small man and woman who devoted themselves to their industries was abandoned by both parties, the Democrats and the Republicans, who in dismantling the Glass-Steagall Act and embracing the interests of Wall Street came to betray the liberty that Jefferson and Madison insisted on. I see glimmers in the land of a renewed interest in this tradition, but I fear, as I said, that today the denouncers of corporate bigness, represented by Bernie Sanders, lack the similar appreciation of the dangers of government bigness, and the denouncers of government bigness, like my friends in the Tea Party, are not always attentive to the dangers of corporate bigness, although I hope that there is a convergence around the idea of that no bank should be too big to fail. Freedom to fail is a slogan that should be embraced by both the left and the right, because any organization that is too big must fail and will fail.
Here we have a couple of pictures that are sort of like related to the legacy, the launching of the Liberty ship named after you, and also over there, Susan Brandeis, your daughter, at Brandeis University. How do you feel being the name giver, if you will, for a university?
Supporting local universities was my greatest passion. I devoted my energies at the end of my life to supporting the University of Louisville at Kentucky. And I told all of my law clerks who wanted to stay in Washington, go back to your home communities. So I devoted myself to the cultivation of the University of Louisville. I gave them my books. I wanted a library that would contain the Greeks and the Romans and books on art and poetry to cultivate the students in Louisville. I insisted that a great biography of Thomas Jefferson, written by Albert J. Nock, who understood that Jefferson was a great libertarian, should be distributed to every student in Kentucky and at the University of Louisville, and I paid to have that Jefferson biography distributed. So Jefferson tells us, democracy cannot survive ignorant and free. That is why I devoted myself to the cultivation of the local university of my home. That is why Jefferson considered his greatest achievement to be his work with the University of Virginia, and that is why I am so honored to have been honored by this university in Massachusetts.
Earlier in our conversation, we already spoke about the opposition that you faced in being appointed to the Supreme Court, and I wondered if you could reflect a little bit, and I think you already mentioned Merrick Garland, but also on the appointment of Neil Gorsuch.
I am convinced that both Merrick Garland and Neil Gorsuch are the finest judges that their two parties could have nominated. Both are able intellectuals who are devoted to their vision of the law as they see it. They would agree about many issues and disagree about others. In some ways, Gorsuch is more of a Jeffersonian than Garland, more Hamiltonian. But each should have been confirmed to the Supreme Court. And the fact that our confirmation process has now resulted in a situation where Garland waited longer than I, my 165 days now surpassed, because neither party will vote for a nominee nominated by a president of the opposite party, is a sign that the polarization of our politics has progressed in a distressing manner.
Perhaps as a last question from me, because I'm already having here some questions from the audience, is to just ask you to reflect on perhaps the current political situation and the state of democracy in the United States.
My thoughts about the state of democracy in the United States are best found, in my opinion, in Whitney versus California, which I want all of you to read. Not now, but after tonight. And in Whitney, I tried to set out my theory of democracy which explain why I believe that the best counsel for evil speech is good speech rather than suppression, and that only speech intended to and likely to cause imminent violence should be suppressed. This is the most speech protective principle in the world, and it's rooted in my Jeffersonian and Athenian faith in reason and deliberation. The framers of the Constitution saw a clash between populism and demagoguery on the one hand, and reason and constitutionalism on the other. And they had faith that given time enough to deliberate, citizens could achieve a public reason that would resist the ministrations of tyrants and demagogues. And that is why, in my Whitney decision, I set forth the following defense for why free speech in democracy is necessary. And I'm going to recite it to you now. And I want you to listen closely to every word so that you will remember them and abide by them in years to come. I begin my opinion by referring not to Madison and Hamilton and the Constitution makers of 1787, but to Jefferson and the revolutionaries of 1776. Those who won our revolution believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. That is a quotation from Pericles' funeral oration. They believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly, discussion would be futile, that with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest threat to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government. Heed those words. Study, educate yourself, develop your faculties, and make yourself worthy of the public reason without which our constitutional republic cannot endure.
So I'm getting more questions here. Wow, there's a lot of questions.
There's always time for questions. There's much learning to do.
Yeah. While you were talking, I was reminded of something that Plato said, that if the people do not engage with politics, we all end up being governed by inferiors. And that is how I would describe our current political situation. I don't know if you have any opinion on that.
The framers read Plato, they read Demosthenes, they read Cicero. They knew that unconstrained democracy can lead to tyrants and demagogues. They had a cynical view of human nature in the sense of understanding that concentrated power threatens liberty, but they were optimists in their faith in education. And the great Madison, at the end of his life, worried about whether new media technologies, like the broadside press, would unite farmers and industrialists and workers so that they were capable of the public reason that Jefferson and I knew is necessary for the survival of democracy and the preservation of the limits on government, of the individual rights, and of the rule of law that is the antithesis of unconstrained populism.
So let me go and look at some of these questions that we got from our audience here. And one of them is, about how you dealt with the anti-Semitism that your fellow judges in the Supreme Court expressed.
I was indifferent to the contempt of vulgarians like McReynolds, who was so anti-Semitic that he refused to attend a court trip to Philadelphia because I was present, and when I would speak during the court conference, he would leave the room, claiming that I'm never to be found where a Hebrew is abroad. But McReynolds' conclusory and dull-witted opinions are now ridiculed by law students for their reasonless vulgarity, whereas my opinions, which address the people with the voice of reason, have had some ability to educate the people.
Here's a more specific question. How would you have voted on Roe versus Wade?
That's a hard question. The privacy of which I spoke in my article on the right to privacy was a form of dignity, not of liberty. And the privacy recognized in Roe v. Wade is more of a kind of dignitary privacy, or really a kind of autonomy, the right of women not to have their bodies invaded, conscripted, taken over by the state. As a defender of liberty, as a libertarian, I am offended personally by the idea that any person should have the course of their life conscripted by the state and have their life path redirected by state intrusion. I say that as a bless you, as a defender of liberty. And yet the Constitution, as I found in my privacy article, does not explicitly protect dignity. And the Constitution does not explicitly protect autonomy. And when Roe was decided, there was no history or tradition of a strong defense of autonomy. Since Roe was decided, the court has repeatedly declared that the Constitution does protect a right of autonomy. And Justice Anthony Kennedy has said in the decision recognizing marriage equality and affirming Roe v. Wade that at the heart of liberty is the right to define one's own conception of meaning, of the universe, and the mystery of human life. As a personal matter, that is a sentiment of which I wholeheartedly approve. Whether it can be rooted easily in the text or history of the Constitution, I am less certain about, but I can say with great confidence that that precedent has been reaffirmed so repeatedly since 1973 that it deserves great weight.
Another question here asked about the limits of preventing bigness in business, and antitrust seems to work only after the fact, but it's very hard to prevent growth from happening. How would you respond to that?
It is necessary. There were three positions in the election of 1912. Theodore Roosevelt wanted to create big regulatory bodies to oversee big corporations, believing that bigness was inevitable, as the question suggests. Taft, the great constitutionalist, wanted more vigorous antitrust enforcement to prosecute wrongdoers after the fact, and Taft brought more antitrust prosecutions during his one term as president than Roosevelt brought in two. Taft doesn't get credit for his devotion to the enforcement of the rule of law. But Wilson and I had a third alternative. We believed that the big banks should be broken up and that large consolidated enterprises should not be allowed to form in the first place. So today, Verizon and AT&T, or Comcast and Mobile and all of these conglomerates must not be allowed to combine in the first place, and the question of whether Google and Facebook and Amazon should be permitted to continue in their consolidated state is one to which the country must devote intense debate.
One criticism in regards to your work was what is described as a silence about civil rights, and is described as a blind spot in your work. How do you explain that?
I had a blind spot on race. I must confess it. I must lament it. I must regret my own short-sightedness. I was not a racist like my colleague Woodrow Wilson. I did not support segregation. I encouraged African Americans who sought advice from me, including the dean of Howard Law School. And I was pleased that Thurgood Marshall was inspired by my brief when he argued his great case in Brown versus Board of Education. But the truth is that I grew up in Louisville. I was not familiar with African Americans. I did not have the experience that I had with women, where my brilliant sister-in-law changed my views about women's suffrage because I worked personally with her. And because of that lack of personal contact, I was not a crusader for racial equality in the way that my colleagues in the Zionist movement were, like Julian Mack, and in the way that other brave white and African American people became later. I'm sorry that I was not as prophetic in matters of race as I was in matters of other forms of equality, and my prophecy has limits for which I am deeply sorry.
I have a hard time reading some of those questions.
It was like me during law school.
I mean, my eyes are perfectly fine, but
Mine are not, and I have
you have glasses.
constitutional reading glasses.
So
But
this seems like an interesting question.
it is. What do you think about the current prevailing student activities and philosophy at universities?
There you
It's
go.
an excellent question. Universities must read my opinion in the Whitney versus California case. My teaching in that case is clear. Speech can only be banned when it is intended to and likely to cause imminent violence. Only an emergency can justify repression, I said in that case. It is unacceptable and unconstitutional for any speaker to be shouted down or denied a platform because his or her words cause offense or wound or cause dignitary injuries. I wrongly toyed with the idea of allowing the suppression of dignitary injuries in my article about the right to privacy. But I came to understand that allowing the law to punish offenses against dignity leads to grave violations of free speech and denies the right of the people to cultivate their faculties by having access to all counsels, evils as well as good, to form their own minds. I abhor the suppression of speech at universities, just as I abhor the effort in Europe to suppress truthful but offensive speech on the internet with a new proposed right to be forgotten on the internet, which comes from the French droit à l'oubli, or the right of oblivion, which is quite French. It's straight out of Sartre. And in Europe, you can demand the removal of any speech that offends your dignity, and Google and Facebook have to take the speech down, and if they guess wrong, they're liable for 2% of their annual income, which in Google's case was, I'm told, was $60 billion last year. This attempt to punish indignity and to remove truthful and embarrassing speech, or to remove hate speech, cannot be reconciled with my teachings in Whitney. The Supreme Court, I am pleased, gratified to report, has embraced my teachings in 1967, and therefore it is unequivocally, clearly, the law of the land that public universities may not suppress hateful but embarrassing speech, and any private university that wants to be faithful to my teachings must resist this evil counsel as well.
Well, I think we're sort of coming to an end here, and I know that you have agreed to sign some of Jeffrey Rosen's book, which I think he would be very happy about if he was here. But perhaps one last question, and I think you need to put on your glasses again because
would you care to opine about the emoluments clause as it applies to our current president? I see from the future, I was so happy to learn about the development of a thrilling new educational tool developed by the National Constitution Center. It is called the Interactive Constitution. And because I'm a prophet and I have access to new technologies, I will show it to you now. And on this thrilling new app, you can find the leading liberal and conservative scholars in America writing about every clause of the Constitution, describing what they agree about and what they disagree about. So when you go to the store and download the Interactive Constitution, not now because you must listen to my answer, but after the answer, you can click on the Foreign Emoluments Clause or any other clause of the Constitution and see the leading liberal and conservative scholars nominated by the Conservative Federalist Society and the Liberal American Constitution Society with 1,000 words about what they agree the section means and separate statements about what they disagree. So when we click on the Foreign Emoluments Clause, we see our two scholars disagreeing about whether or not the clause applies to the president. Here it is along with the Export and Port Preference Clause, the Appropriations Clause, the powers and duties of Congress. There's so much to learn, ladies and gentlemen. You must download this app, and you must click on each of these clauses and read the learnings of the scholars so that you can educate yourself. I don't know the answer to this question because I haven't studied it properly, and nor should you, but I have read the Interactive Constitution, and there is a debate about whether or not the Emoluments Clause was meant to apply to the president. Washington accepted gifts from foreign governments, and Hamilton insisted that the Emoluments Clause only applied to appointed officers, not to elected ones. William Howard Taft, when he was Secretary of War, turned down a gift from the Emperor of Japan, a beautiful Gobelin tapestry, because he thought it violated the Foreign Emoluments Clause. The problem was that Taft's wife, Nellie, really wanted the tapestry. So she appealed to President Roosevelt, who decided that she, unlike Taft, was not an official of the United States, and Nellie got to keep the tapestry. So the answer to the question is that there is a debate about whether the clause applies, but ever since the Jackson administration, presidents have assumed that the clause did apply to the president. Your President Obama was able to accept the Nobel Peace Prize only after his Office of Legal Counsel opined that although the clause applied to him, the Nobel Committee was not a foreign government, and therefore the Emoluments Clause did not apply. And therefore, I think it's fair to say that the balance of authority suggests that the Emoluments Clause does bind the president. Whether his business dealings violate the clause is something that you, the people, will have to decide for yourself.
So if there are any burning questions, Mr. Brandeis is going to sign Jeffrey Rosen's book. But I wanted to thank you and also say that by having you here, it makes clear again that the museum is an institution for education and a place for public discourse, which you have clearly proven here with our conversation. And I want to thank you very much for coming here. And before I end, please save the date on June 22nd. We actually have another person here coming from Prague, Franz Kafka, who will be in conversation with me, and it's promising to be another wonderful event. So thank you very much, Justice Brandeis.